Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Welcome back to the deep dive. Today we're jumping straight into a really significant high court ruling out of India. It's all about patents in the pharma world. Specifically, it tackles this crucial question: when does a potential threat from a competitor become, legally real enough to stop them in their tracks before they even launch?
That's right. It's about the concept of quia time acting because you fear something imminent. And this case sets a pretty high bar.
Okay, let's get the basics down first. The administrative facts, the who, what, where, when.
Sure. So the case is CSCOMM 1188-2024. It's from the High Court of Delhi at New Delhi. The judgment was just pronounced, actually September 26, 2025, and the judge was Justice Amit Bansal.
And the players involved.
On one side, the plaintiff, Helsinn Healthcare SA. They're a Swiss pharmaceutical company. Their senior advocate was Mr. Jayant Mehta, and they were up against two defendants, AET Laboratories Private Limited, that's defendant 1, the Indian subsidiary based in Hyderabad, and defendant 2, their German parent company. Representing them was senior advocate Mr. Dayan Krishnan.
Got it. And the core issue, what was the fight actually about?
It's a patent infringement suit. Helsinn wanted a permanent injunction to stop the defendants from infringing their patent, Indian patent number 426553.
And that patent covers what exactly?
It covers a specific oral drug combination, netipetant and polonicitron. Helsinn markets this as AKYNZEO. It's used to treat nausea and vomiting caused by chemotherapy. Helsinn had actually launched AKYNZEO in India way back in May 2018, so they were already established in the market.
Okay, so Helsinn has the patent, they have the product on the market. When did things start to heat up with these defendants? Let's get the timeline.
Well, the defendants, the German parent and the Indian subsidiary, were developing their own version, a fixed dose composition, or FDC, of the same drug combo. Helsinn understandably saw this as the impugned product.
Right. When did Helsinn start to feel the threat was becoming, actionable?
Things really ramped up in 2024. It started back in March 2024. The Indian subsidiary D1 filed a post-grant opposition against Helsinn's patent.
Okay, that definitely signals interest in the market.
Exactly. Then, fast forward to October 2024. The German parent company, D2, was actively promoting their version, the impugned product, for the European market at a big pharma event, CPHI Milan.
Oh, international promotion.
Yeah.
So domestic challenge plus international visibility.
Precisely. So Helsinn put those pieces together, and by December 2024, they went to court. They filed the suit and managed to get an ex parte ad interim injunction.
Meaning they got a temporary stop order, freezing any potential launch in India by the defendants, right?
Yes, exactly, a temporary freeze. But of course, the defendants weren't going to just accept that. They challenged it.
Which brings us to the core legal battle. The court had to decide if that initial injunction should stand. What were the key legal questions?
It really boiled down to two main things. First, the quia timet question. Did Helsinn actually show a strong enough basis to fear an imminent infringement? Was the threat real and immediate?
Okay, imminence. What was the second question?
Territorial jurisdiction. Did the Delhi High Court even have the authority to hear this case? Remember, neither defendant had an office or factory in Delhi. D1 was in Hyderabad.
Right, so two major hurdles for Helsinn to keep that injunction alive: proving the imminent threat and proving Delhi was the right place to sue. This is where it gets really interesting. Let's dive into the arguments. How did Helsinn try to convince the court on these 2 points?
Well, on the quia time front, they argued the apprehension was totally justified. They pointed to D1 filing that post-grant opposition clear commercial intent, they said. Then D2 promoting the product internationally at CPHI. And crucially, they alleged that D1 was already making the product in Hyderabad and exporting it for the EU market. Add it all up, they said, and a launch feels very close.
That sounds plausible. I mean, challenging the patent, promoting the product.
Yeah.
What more do you need?
Helsinn certainly felt that way. And for jurisdiction, they argued a couple of things. First, they showed that other products made by the defendants were being sold in Delhi, pointing to listings on platforms like IndyMart.
trying to establish a general business presence in Delhi, essentially.
Yes. And second, they argued that the defendant's own website, which mentioned the new drug as under development, was accessible in Delhi. They said, in today's world, website access should be enough to create jurisdiction, targeting Delhi consumers online.
Yeah, makes sense from their perspective.
Yeah.
So how did the defendants push back? What was their counterattack to get the injunction lifted?
They came back hard. On the key timet point, their main argument was this product is basically still on the drawing board. They called it nascent.
Nascent.
Meaning it was nowhere near ready for the Indian market. They emphasized, and this is key, they had none of the required regulatory approvals, no clinical trials completed in India, no green light from the CDSCO, the Central Drug Standard Control Organization, or the state drug authorities.
The regulatory angle. So no approvals, no possibility of a launch.
That was exactly their point. They argued you cannot legally launch in India without those approvals. So listing it as under development or promoting it overseas, that's just, advertising or maybe planning. It's not an offer for sale under Section 48 of the Indian Patents Act.
So a crucial distinction they're drawing between just talking about a product and actually being ready to sell it under the patent law.
Precisely. And on jurisdiction, they were just as firm. They said, look, we have no office in Delhi. D1 is based entirely in Hyderabad.
And the website argument.
They basically said, just because someone can see our website in Delhi doesn't mean we're targeting Delhi or doing business there. They argued mere accessibility isn't enough. Helsinn needed to show actual proof of commercial activity in Delhi related to their products.
Okay, so a real clash here. Intent versus readiness. Website access versus targeted business. How did the court land on this? What was the decision?
The court sided with the defendants. It allowed their application and vacated the interim injunction.
Wow. So Helsinn lost the temporary protection. Why? Let's unpack the court's reasoning, starting with the quia timet failure. Why wasn't the threat considered imminent?
The court was very clear. Filing a patent opposition, that's just exercising a legal right. It doesn't automatically mean you're about to launch an infringing product. But the absolute deal breaker was the lack of regulatory clearance. Justice Bansal specifically pointed out that without completing clinical trials and getting approvals from bodies like the CDSCO, the defendants could not legally launch in India.
So no CDSCO approval, no imminent threat. That's simple.
Legally speaking, for the purpose of a quia timet injunction in this context, yes. The court saw the threat as speculative, not imminent, without those regulatory milestones being met.
That really draws a line. And you mentioned the difference between patent law and trademark law earlier. Did the court elaborate on that?
It did, and it's a really important distinction. The court noted that under India's Trademarks Act, Section 29, even just advertising can constitute infringement. But under the Patents Act, Section 48, the standard is higher. It talks about making, using, offering for sale, or selling the patented invention. The court found that simply listing a product as under development on a website or promoting it generally isn't an offer for sale. It's more like advertising or signaling future intent.
So patent holders need to show more than just promotion to get that pre-launch injunction. Did Helsinn cite any previous cases where injunctions were granted?
Yes, they relied on cases like Novartis and Shilpa Medicare, but the court distinguished those. It pointed out that in those specific cases, the defendants had actually already obtained a manufacturing license in India or other key regulatory approvals.
So those defendants had crossed that regulatory threshold.
Exactly. They had taken concrete steps demonstrating they were practically ready to enter the market. Helsinn's defendants hadn't reached that stage yet for the Indian market.
Makes sense. A very practical test. Now, turning to the second pillar, jurisdiction. Why did the court say Delhi wasn't the right place? What about the website in the India Mart listings?
Here, the court leaned heavily on a major precedent, a division bench ruling called Banyan Tree Holding v. Murali Krishna Reddy.
Banyan Tree. What does that case say about internet jurisdiction?
It sets a high standard. Banyan Tree essentially says that just because a website can be accessed in a particular place, like Delhi, doesn't automatically give the court their jurisdiction.
So what more is needed?
The plaintiff needs to show something called purposeful availment. They have to demonstrate that the defendant specifically targeted residents of that place, Delhi, in this case for commercial transactions through the website. And crucially, the Banyan Tree test usually requires proof that some commercial transaction or interaction actually happened or was solicited in that jurisdiction.
So Helsinn needed to show the defendants were actively trying to sell to people in Delhi via their site or that someone in Delhi actually bought something.
Pretty much. And Helsinn tried to do that with the IndyMart evidence for that other product, Positif. They filed extra documents showing those listings.
But it didn't work.
No. The defendants managed to counter it effectively. They provided shipping details showing those specific IndyMart sales were either exports out of India or deliveries strictly within Hyderabad.
Ouch.
Yeah. The court concluded that Helsinn failed completely to show any customer, any sale, any confirmed order, anything connecting the defendant's commercial activities specifically to Delhi. Mere website access wasn't enough. They didn't meet the banyan tree standard.
So, a failure on both counts, no imminent threat established, and no territorial jurisdiction in Delhi proven. And since this was an interim stage decided by a single judge, there wouldn't be any dissenting opinions, right?
Correct. No dissent or concurrence here, just the single judge's ruling on the interim application.
Okay. So, stepping back, what's the larger significance of this ruling? What does it mean for patent holders, especially in pharma, going forward in India?
I think it sends a really clear message. It significantly raises the procedural bar for getting these preemptive quia timet injunctions in patent cases. You can't just rely on competitor announcements or preliminary steps like filing an opposition or international marketing. You need tangible proof of steps towards imminent commercialization within India.
And for pharma, that tangible proof seems to be regulatory approval.
Overwhelmingly, yes. Getting that CDSCO approval, or a state manufacturing license, appears to be the key indicator the courts will look for to establish imminence. Until then, the threat might be seen as too speculative for an injunction. It also strongly reinforces the banyan tree principle for jurisdiction based on online activity. You need proof of targeting and actual commercial interaction, not just passive accessibility.
Right. So if we had to boil this down to the single most important takeaway for someone listening, maybe someone involved in patent strategy or litigation, what would it be?
The key takeaway is this. If you're seeking a quia timet patent injunction in India, especially in the pharmaceutical sector, intent isn't enough. General promotion isn't enough. You absolutely must demonstrate that the defendant's threat is imminent by showing concrete preparatory steps within India that make a launch legally and practically possible in the near future. And right now, the clearest evidence for that seems to be securing those mandatory regulatory approvals, like from the CDSCO. Without that, your case is likely premature.
Crystal clear. Prove they're actually ready to hit the market here, not just thinking about it. We've gone from the case details right down to the nitty-gritty of offer for sale versus advertisement and the banyan tree test. A really insightful deep dive.
Absolutely. And perhaps it leaves us with a final thought to chew on, especially relevant in today's globalized pharma industry. Consider this scenario. A company sets up manufacturing in India, maybe in Hyderabad, like D1 here. But their explicitly stated market, the only place they intend to sell initially, is outside India, say, the EU. They get export approvals, maybe, but deliberately don't apply for Indian CDSCO approval because they aren't targeting the domestic market yet. How long does a patent holder have to wait? Does the fact that the infringing product is being made in India, even if only for export, eventually create an imminent threat sufficient for an injunction in India, even without domestic regulatory steps? Or does the lack of domestic approval shield them indefinitely as long as they only export?
That's a fascinating question about jurisdiction and imminence when manufacturing and market are split. Something for future cases, perhaps.
Definitely food for thought. Thanks for breaking that down for us. And thank you all for joining us on the deep dive. We'll catch you next time.